The Appellate Division Court Department. Hear ye, hear ye, hear ye. All persons having business before this court may draw near, give their attention, and they shall be heard.
Okay, good morning, everyone. Have a seat. All right. The first case that we'll call this morning for argument is case number 547, People versus Jenny Clark. Ms. Plank?
Yes, may it please the court. I'm Tanya Plank on behalf of Jenny Clark. I just want to note that Ms. Clark's parents are here in the courtroom. I'll begin with the waiver of appeal. Our argument is that because point one involves a challenge to the voluntariness of a plea, it survives the waiver, but in the alternative, the waiver is invalid anyway. In its oral colloquy, the court told Ms. Clark that she waived her right to make a CPL 440 motion, which is affirmatively wrong under the Green companion case to Thomas. And here, although the written waiver was better, it followed the model colloquy. In this case, the written waiver didn't say anything about the 440 motion for one thing. And for another thing, the court never ascertained from the defendant herself whether she read and understood the written waiver. Her attorney said that she did. And so I would argue that under People v. Elmer and People v. Ware, that's not enough for the written waiver to cure the oral colloquy.
Hey, Ms. Plank, can I just ask, is this issue preserved for us to review?
No, it's not. And therefore, we would ask that this court review it in the interest of justice.
Okay.
So yes, turning to point one, though strictly speaking, Ms. Clark didn't expressly negate depraved indifference. When viewed under a totality of the circumstances, her plea was not knowing, intelligent, and involuntary. Depraved indifference murder is one of the hardest, most complicated areas of the law to understand. As the Court of Appeals made clear in People v. Suarez, judges and attorneys have repeatedly confused it with intentional murder and misapplied it. So that would make it all the more difficult for a layperson to understand. And here, no one alerted Ms. Clark to the critical meaning of the mens rea element of depraved indifference murder. First of all, I mean, as the prosecutor pointed out, this is a non-existent crime. Attempted depraved indifference murder is a non-existent crime. There is case law saying that it can be pled down to, but in this case, I would argue that makes it, the fact that it's a legal impossibility combined with the difficulty of understanding depraved indifference murder and the distinct mental state.
Counselor,
Yes.
I guess my question would be in reference to something similar that Justice Bannister requested or indicated or questioned was whether or not this is preserved as well. I don't think there was any motion to withdraw or vacate the judgment.
No, there was no motion to withdraw. So this is not preserved. And so we are asking that the court review this in the interest of justice.
Okay.
And let me ask another question. Okay, it appears to me in the record that this issue about repugnancy and impossibility, that was discussed with defendant and her counsel prior to entering into this plea. And it was something that they did for her benefit, wrapped up with a sentence commitment and all that. Do you deny that that's in there? Or?
Well, it's not clear. Obviously, it's not on the record what defendant and her lawyer said to each other. So that would have to be the basis for any motions. This is not in the record, but I would argue that it's not clear that they discussed that and that the attorney actually said that.
But it is clear that counsel discussed it with the court.
Counsel discussed it with the court, yes. Yes. So, and she was there. I know the people point that out in their brief, and she was there listening to the prosecutor and the attorney talking about that. But that doesn't mean that as a lay person with no experience with the criminal law that she could understand that.
Looking at the totality, though, that took this plea with an understanding that, well, by taking this plea, it's going to be we're going to avoid having to play the recording from the cell phone.
I'm sorry.
You have to avoid playing the recording from the cell phone.
Oh, the recording. Yes. There's a lot that's not on the record here about how Ms. Clark felt and what not wanting to put her daughters through a lot. But yes, they wouldn't have had to play the recording, obviously, if they took this plea. But I would still argue that.
And that was pretty damaging.
It depends on, I guess that would be for a jury to decide,
Right.
whether that, and it goes, and the prosecutor's arguments mainly went to intentional murder and not depraved indifference. So I would argue that it's very problematic, that this plea is very problematic. If it's not too intentional, it's too depraved indifference, and that's
Well,
problematic.
if she went to trial and was found guilty of the primary charge, then she could be looking at life in prison.
Right, that's true. That's true. So there was a big risk, definitely. And thirdly, I would argue if this court is not inclined to vacate the plea, to please consider the sentence. This is one of the most remorseful people I've ever met. She has said, as she said to the judge in her sentencing statement, she will regret this forever. The evidence shows that she pressed hard on the brakes and skidded to avoid the pole. That's substantiated by her daughter's letter. This was a complete aberration of character fueled by alcohol and probably the extreme distress she was experiencing from her husband's illness. She has no criminal history whatsoever. She poses absolutely no danger to society. This is very unlikely that this will ever happen again. She has a strong job history, a huge community support, which is obvious from all the letters submitted on her behalf, and including Mr. Clark's parents and including their children. And I would just add briefly, as her daughter Marley, as her daughter wrote in her letter to the court, that she's very concerned that they're living with the grandparents now. The grandparents are elderly, and they may not be able to care for them for 20 years. And there's a possibility that the girls are young, they may have to go into foster care. So the daughters are very concerned about that. So we would ask for all those reasons that this court reduce the sentence to a term closer to the statutory minimum, which is only 5 years.
Thank you.
Are there no questions? Thank you.
Counselor?
Morning, Marty McCarthy for the people. I want to start with how this plea came about, because it wasn't, the people's offer was the man's first plea, which was the B felony. This was the defendant's choice. The defendant chose this. They negotiated with our office to plead to this count, this charge. So that needs to be borne in mind by the court when it's considering the unpreserved issues regarding the colloquy here. There was no requirement that there actually be a factual colloquy at all because it was a reduction. There was nothing here that in terms of the colloquy that should have given the court any pause with respect to what she said. I was thinking that you might want to hear my views on sentencing. Is that accurate?
Sure.
Okay. I will concede that this is not the usual case that I'm up here arguing about harsh and excessive on. I understand the conundrum that the trial court felt when it was trying to impose what it felt was a just sentence in this case. I understand your conundrum in trying to figure out whether that sentence is harsh and excessive. There's a lot of mitigating circumstances on the side of the defendant, but the one thing that doesn't mitigate against her is just the absolute gravity of this offense. And it wasn't just the fact that she killed her husband. It was that she killed her husband in front of her children. And they had to watch their father die. Like, to me, the gravity of the offense outweighs the mitigating factors. And I'm glad I'm in my position and not your position. I understand how difficult that is for you to maybe wrestle with. But in this scenario, the gravity outweighs the mitigating factors.
I think she's what, 44 years old, maybe at this point?
And I concede everything that
Right.
Ms. Plank said about her history is accurate.
Right, and the 3 children, I think were the ages, I think the oldest is 14.
Yes.
You know,
So she
12
had-
and 8, you know.
He had 3 children. I
I guess there is a circumstance where there's a possibility of somehow being placed in foster care. I mean, that's down the road, and I don't know the health of the grandparents, but
and neither do I.
right. I mean, that's not, it hasn't been made part of the record, or whatever it might be, but you know, those are things that are weighing on the court as far as whether or not it's somewhat a situation where it may be harsh or excessive.
And I can appreciate that,
Yeah.
but
Right, and I can understand your position as well. Looking at this, you know, this action took place, arguably intentional. I mean, here we go. Here we go now, and the comments that she was making and the statements that she was making and the And the children had to witness that.
Yes,
You know, but,
and
and again, but you still have a letter from the daughter herself.
one daughter.
Explaining, right,
One
the
daughter.
oldest
So
daughter, right?
what we have is a view of one of the
Right,
children.
I mean, she's 14, there's maybe 12 and 8, maybe, you know, obviously, they're all traumatically affected by this, I'm sure.
The court had to watch the video as part of its
Right.
grand jury minute review.
Mhm.
And the terror that is in that car was palpable.
And I think even one, maybe it was the middle child, had to buckle their seatbelt.
Yes,
I understand.
because she was sitting in the back, she was sitting in the back seat, she wasn't buckled.
Right.
And she realized what was going on. She could have been ejected from that car, she could have
Exactly.
killed.
Exactly.
You know, that's what I'm sort of wrestling with as a prosecutor standing before you. When I think about that type of conduct, I would have to submit that the sentence here wasn't harsh and excessive.
But it was a negotiated sentence, wasn't it?
It was a negotiated range. I believe it was 18 to 23. And the judge fell right in the middle of what was negotiated. The people advocated for the high end, the defendant advocated for the low end, and the defendant chose, the court chose 20. Okay. There are no other questions? Rest of great. Thank you.
Counsel. Case number 548, People versus Weems. Okay. Mr. Keem, can you hear us?
Yes, I can. Can you hear me?
We can. Why don't you go ahead?
Good morning. May it please the court, Brad Keem for Malik Weems. Here, the trial court failed to follow CPL 3030 sub 5. Defense counsel objected to the trial court failing to review the people's actual readiness, and instead delegated its duty by creating a process by which the parties would conduct a discovery conference and then create a document detailing their differences. Such a process is not contemplated by 3030 sub 5, which mandates that the trial court review the validity of a statement of readiness upon such a statement by the people. We also assert that it's not waived by the guilty plea because further objection by defense counsel would have been futile. If the court doesn't have questions on that issue, I'll move to the youthful offender. Here, we'd ask the court to substitute its discretion and find Malik a youthful offender on the basis of this incident. Malik took responsibility for his actions. Probation recommended a youthful offender adjudication. There was
Mr. Keem, let me ask you a question. How does that even work here? Okay, where between the time of the plea and the sentence, he pleads guilty to murder in another court. How could this even assist him, or how can it even help him? And secondly, knowing that, why would we do that? Two questions.
Sure. It would help him because it would be a youthful offender adjudication as opposed to a felony conviction. So in the event, he's a very young man. So in the event that he is out, and he wouldn't then be subject to predicate felony offender, some kind of predicate in the future if he does commit another crime. And I think it's worthwhile to note that the probation department knew very well of the murder allegations and his election to enter a plea on that, and still recommended a youthful offender adjudication in this matter. And that's because there was a lack of knowledge as to what Malik's actual role in that incident was, and that the individual who was really the leader here, Mr. Marte, who was the victim in this case and who tried to get the younger Malik to take the blame for this, really held Malik in his sway, and exactly how youths are taken advantage of by older, more established criminals like Mr. Marte. Malik does have strong family support. He has a great attitude. He is a person that I believe when he's going to be out in 18 years, that he will do something with his life having a youthful offender adjudication here as opposed to a felony conviction, I think would be greatly helpful for his future. Unless
Okay.
there are no questions on our other issues, then we'll rely on our brief.
Thank you.
Morning, Your Honors, Caitlin Porter on behalf of the people. To the extent that defense counsel raised an objection below, it was to the court's 245-35 sub 1 order. It was not there was not any mention of the court's inquiry or requesting that the court even make an inquiry after the people filed their COC and declared readiness. So there was, we would argue then that it's entirely unpreserved and it would need to be preserved in order for consideration by this court. And even if it were preserved, it would have been otherwise waived by his guilty plea. So I would ask the court not to even reach that issue based on the preservation aspect and also the waiver. On the YO point, as Presiding Justice Bannister pointed out, there is sort of a pragmatic consideration here. The defendant is a convicted murderer, as well as his kidnapping in the first degree plea. Those offenses predate this offense, but he was convicted in the interim before sentencing. So when we're looking at the benefit of a YO adjudication, we're looking at giving someone the possibility to have no criminal record, to give them that fresh start. That really wouldn't take effect here. The defendant would still have this on his record regardless. So there is still that pragmatic aspect when the court's considering whether to exercise its interest of justice jurisdiction or whether the court below abused its discretion. On that, as laid out in our brief, there are a number of points to beyond the fact that he already will have a significant criminal record based on that conviction. There are a number of reasons why the court properly exercises discretion in denying YO adjudication. The defendant's portrayal of himself sort of as this passive observer and putting all the blame on his co-defendant, that only comes from the defendant's claims at sentencing. Beyond that, it doesn't really seem to comport with the information that we have in this PSI based on his history, his participation in numerous gangs, including a gang before he ever met the co-defendant that he blames for his actions. And then he was removed from that lifestyle, moved to Pittsburgh with his mother, but then returned to the area, found a different gang to be a part of. And that's when he met the co-defendant. So his history, his acts of violence really don't support a YO adjudication in any event, beyond the fact that it wouldn't really serve any practical purpose in this case. Unless the court has any additional questions, I will rest on my favors.
Thank you very much. Case number 549, People versus Daniel Langdon Jr. Hey, Mr. Gilman, you're alone.
Yes. Good morning. May it please the court, Braden Gilman for Daniel Langdon. I'll primarily focus my argument today on point 1, unless there are other questions. Mr. Langdon did not knowingly, voluntarily, or intelligently waive his right to an appeal. Here, the court deviated from the model colloquy in its explanation for Mr. Langdon. Notably, the court explained what an appeal would be and what an appeal could compass here. And in that, it described that an appeal would encompass the circumstances of his arrest. When it moved into the what an appeal waiver would encompass portion, the court only talked to the specific, only specifically mentioned the severity of the sentence as being waived. There was no explicit mention of the circumstances of arrest or any other potential claim as is called for in the model colloquy. So where there was an ambiguity as to this explanation of what could be in an appeal and then no mention in the what would be waived portion, there was an ambiguity, and I think the court should consider that. Where here,
Counselor, is that your position here that this colloquy is defective because the court did not enumerate the claims that were waived specifically? That's your contention here.
Well, yes, because it deviates from.
In other words, that in any circumstance, and your position then would be that the court's responsible for announcing specifically with each defendant what claims relative to their particular situation would be waived. That's your position?
Well, I think it's slightly different in that the court identified in the appeal portion that this is what could be the circumstances. When it got to the waiver, there was no mention. And then also the additional claims that would survive, the jurisdiction, voluntariness, what the court is more than aware of is nowhere in there is the mention of the circumstances of the arrest. And then combined with the written waiver here, which was used, very broad language, including all aspects of the case would be waived. And then it specifically said the events leading up to the arrest, but the circumstances of the arrest weren't mentioned. There was also an important distinction in it spoke to the legality of the plea and legality of the sentence as being as surviving waiver, but there was no mention as to jurisdiction as well as the actual appeal waiver. And then it also deviated from the oral colloquies in the model colloquy, how they describe the voluntariness of the plea rather than what's written in the waiver being the legality of the plea. And when we look at all those factors together with Mr. Langdon, this being his first his first experience with the criminal legal system, that that ambiguity should be read in favor of Mr. Langdon. And we would just ask the court to consider that unless there are any other questions.
I think we're good. Thank you very
Thank
much. Next case is number 552, matter of Ibn and Muha. Okay, and I think we have Mr. Pajan on the screen. Mr. Pajan, good morning. We can't hear you. You got to unmute yourself. There you go.
Okay. Well, my video kicked off. I can't explain that, but
We can see you.
Oh, you can.
We can see you. You might not be able to see us, but we could see you.
All right, great. This is the case where the father entered a plea of guilty to manslaughter 2 on an Alford basis and claims on this appeal that it is not binding on him in terms of the finding of child neglect or abuse, rather. Everything I have to say factually is contained basically on page 9 of my brief. If there are no questions, I'll move on.
Any questions? Thank you for joining us, Mr. Pajan.
I do have
hold on
one
one second.
I just do have one question. Are you relying solely on the collateral estoppel, or, I mean, isn't it couldn't we consider the fact not only that it was the Alford plea that he took, but also the rest of the paperwork, the affidavit of the child, the certified statement, we can consider all of that, couldn't we?
Absolutely. And the motion for summary judgment did include all of those papers, including the older child's narrative of the death of his mother in his presence. Is pretty horrible. Yes, all that stuff should be considered, Judge, and it is in the appendix, and it's argued in my brief.
Okay, thank you, Mr. Pajan.
All right, thank you.
Case number 553, Wasicki versus Wilbur. Okay, all right, we have our person who joined us. Can you hear us on the video?
Yes.
Mr. Oden? Okay, very good. All right.
Good morning. May it please the court. Stephanie DiGiorgio for the appellant. I'm going to focus this morning on points 2 and 3 of my brief, but I just want to say I think this case focuses on one thing. Although there's a number of sporadic issues, I think it boils down to communication, whether that is lack of communication by one or both of the parties. But I think that that's what the real issue is here in this case. The trial court found a change in circumstances based on the parties' lack of communication and deterioration of that of their relationship. Specifically, the court noted the back and forth between the parties, encouraged each other, to be more entrenched in their positions. It also said that neither party could communicate, and both were controlling to the detriment of the other.
But neither party disputed the change in circumstances, did they?
Correct, correct. Neither party disputed it, and I would submit that, as I focused on in point one of my brief, that even though the trial court found a change in circumstances based on that, she continued the award of joint custody, and I submit based on point one that they should have awarded it to the appellant sole custody. But taking that aside, if the court found that there was enough there to continue the award of joint custody, the error really falls that it shouldn't have awarded these rotating spheres of decision-making between the parties. I don't dispute, and I don't think my colleagues would dispute, that the court has the authority to award spheres of decision-making in these cases. What I
Is
think
your argument, Counselor, that they're rotating, the alternating, you're on, you're off for dental, medical?
Yes, I mean, there's case law to support that courts have decision-making. Mom gets medical decisions, dad gets dental, mom gets school, dad gets, extracurricular activities. It's extremely problematic to have a rotating schedule that's based on a yearly schedule. I mean, especially in family court matters, you have people who are constantly in family court, constantly have issues. And if you have parents, which in this case the court said, have issues communicating, it just adds fuel to the fire, moving forward. You can imagine situations where you have parents.
Isn't there a danger in this that one parent could have a doctor and then next year when the other parent has it, chooses a different doctor or different dentist, whatever it might be? I mean.
Absolutely. And one parent orders the surgery, the other one says, nope, we're not doing this.
Right.
And, it also creates problems, not that the court necessarily is concerned with providers, but it does affect the child. You have multiple providers changing back and forth. Doctors don't know who's making decisions this year, who's making decisions next year. What happens if, we're trying to get someone in for an appointment that's 6 months later and it falls in a different year? It's extremely problematic. And I think, again, the real issue in this case is that alternating year schedule. So I'd ask the court to look at that. And again, if the court finds that there is enough to support the continuation of joint custody, I'd ask that the court specifically address the rotating years for the spheres of decision-making. With respect to point three, the violation, the trial court found that there was a willful violation of the order based on two things: the preschool decision making, as well as the parties' respective vacations in July and August. With respect to the vacation, both parties acknowledged that they missed the May 1st deadline. Both parties acknowledged that they each sent each other late their dates.
But the mother did not file a violation petition or a petition by a violation, right?
She did not. Both parties got their respective.
But the father did.
He did, and he also ultimately did it a couple days before even she exercised her time. But I would submit mom did give dad the time that he asked for his July time, and that would have been before. And with respect to the time missed, I think it's presumed that both parties, when you take a week off on your vacation, it's going to interfere with someone's respective parenting time. So I think by the nature of them saying we're going to pick our dates late, picking the dates, it's going to interfere with, with their parenting time. With respect to the preschool, the order did say that the parties, if the parties were unable to agree to a preschool, it would be dictated by where the mother resided, in which case this was Clinton. There was no unequivocal mandate within the order itself saying you have to discuss preschool or what preschool in Clinton. And I would submit that even if there was that mandate, mom did have a number of factors to malate that finding. Once there was a preschool that had an opening, she did communicate with dad, give him the registration information.
I'm going to stop you for a second. I'm going to ask you a more general question. All right, so this order was, what, a year ago? Have these parties still continued to be as unable to get along as they were back when this order was issued?
Yes, and I would say that, the concern is it's only been a year. This child is very young. So even if theoretically they were doing well for the last year, that doesn't mean 6 months from now, we're not going to be back, back in at the trial level, litigating issues relating to their communication. And
because to me, this order from the court was sort of a warning. If you don't learn how to get along, this is what you're going to have to do. And this kind of stinks. Okay. So the court threw something out to them. If if you want to do what isn't so convenient, figure out a way to talk to each other, okay? And keep the court out of your life and cooperate and do it for the best interest of the child. But from what you're telling me, they haven't really learned that lesson yet.
I mean, to my knowledge, there hasn't been any new filings.
Well, that's good.
But I don't know that this necessarily clarified going forward. I think,
It's May 21st. Do they pick their vacations?
I hope so. But I don't, again, just speaking on that, again, I agree this is all about communication. And I think maybe if the court didn't award this flip-flopping, maybe it really would have been a final order and maybe the parties would have been able to work with that and run with that.
And it seems to have a little to do with winning and losing, you know, which is also unfortunate.
Agreed. And I think that was clear, because again, it seems to be a little contradictory in my eyes. You find clearly that these parties cannot communicate, then you continue joint custody, and then you allow this back and forth to occur. So I absolutely would agree, Justice Bannister. And then just lastly, with respect to the counseling, I'll just touch on that. Again, I don't know that there was any evidence other than a brief statement that mom didn't like communicating with dad, other than through text message, which is not uncommon in family court situations. They have been able to communicate through text message before. That's how they've done all their communication. She had some comments that she was afraid of dad, that in the past he had put his hands on her and that she liked it to be written forms of communication. But I don't think that was enough to warrant the requirement that she continue in counseling. So unless the court has any other questions, I'll roll on.
Plus, if say, you know, the mother, she's objecting to this counseling, say she didn't even do it. So she doesn't want to do it. I don't think I have to do this. Now she's subject to a potential violation.
Correct. Unless the court has any other questions, I'll rest of my brief.
Thank you very much.
Thank you.
Jay Williams on behalf of John Wozicki. I think we can agree that the way parties in these situations communicate is via text message. We see this in all sorts of family court cases. And these parties communicated extensively. The problem wasn't that they didn't communicate. The problem was that he was vetoed, and he could say whatever he wanted, but she would never, she always had the final decision making. The order from Judge Brulette, who was there, who heard the proof over a number of days of trial, was that both of these parties are very competent people, and both of these parties should have the ability to make decisions for their children. And she came up with, I think, a very creative way of dividing the spheres of influence and then rotating them year on, year off. I think the question was, you know, how is this going? My client was extremely surprised that the appeal was proceeding because things, he said, have never gone so well. There haven't been any problems. Whereas before this, we had numerous trips to family court. There hasn't been any trip since. So I believe that this is the judge who was there, who heard the testimony, who saw the demeanor of the parties, was the person who was best able to make the determination as to what the best way forward is. And I think that this particular scenario, which has been proposed by the court or ordered by the court, should be given time to work and see how it goes. And I think unless there are problems, it should stay the way that it is. In regard to the violation petition, in regard to the summer vacation, I would point out that contrary to what counsel said, when the father picked his July time as the July 4th weekend, the mom said, no, my parents are going to be in town that week, pick another week, which he did. In regard to the August visitation, mom picked a time for visitation, which was not just August, but also September. And not only was it late, but it went into September, interfered with the Labor Day plans. She wouldn't change that. And that's coupled with numerous times where she would not do any kind of cooperation with the father, including even going to allow the daughter to attend his father's celebration of life service when his father died on Father's Day.
So wasn't there a $500 fine imposed for the violation?
Say that again?
Wasn't there a fine imposed?
There was a fine.
Okay.
There was a fine.
Wasn't that, then that that particular issue addressed?
Yeah, that's, and regarding the fine, that was up to the court, I guess. We took no position on the fine, and quite honestly, it's a de minimis fine in the greater scheme of life. That's not my client's big concern. It isn't.
And your client's concern is that it would be okay for 1 year, the health of the child, the doctor may change from 1 year to the next when they don't already get along?
The issue right now has been, they're getting along because neither party has a veto power over the other. And if one party understands that next year the other party will be able to make a different decision, that encourages them to work together, which they are doing.
But they didn't have veto power initially, and they just vetoed when they felt like it.
Right. My client was vetoed. My client didn't have any ability to tell the mother no. She just would make all of the decisions. By imposing this new schedule, both parties have the ability to make decisions, and knowing that both parties can make decisions on a variety of issues, that encourages them to work together, as they should have from the beginning, to resolve these problems. So I think that beyond just the simple back and forth, that's not the issue. It's getting everybody involved in making decisions, and knowing that the other party is making decisions, and next year may be able to make decisions. So that encourages cooperation, which I think is extremely important for this couple.
With regard to that $500 fine, are you claiming that the father or the mother had veto power over the preschool selection?
She did. She was.
Didn't appear as though the father made any real efforts from April till August, when the selection was made, when these schools were filling up and waiting lists were required. Didn't appear as though the father made any real effort until August, when he suggests, well, maybe one of these schools has a waiting list, so try them. But she already had St. Mary's selected, which is in Clinton. And I think no agreement in writing before, so the order itself indicated that.
So I think that the father's conduct could the father have enrolled the child in a daycare situation just on his own?
I guess my question is, he didn't appear to make any effort, according to in the record. Other than August.
His offer, he asked to sit down with her or discuss this numerous times. What we're talking about is, first of all, his preference for daycare, preschool, I should say, was the VVS school district, which there were open spots. It was free, but it was in his district. So mom said no to that. So, and as the order said, if you can't agree, then it will be in the Clinton school district. There are three, there are four. One just closed, but there were at the time 4 daycare preschool programs in the Clinton district, and he asked her a number of times.
He asked her basically, what's going on with that? I mean, can we talk about that? Basically,
right.
She said, I'm working on it, whatever, and
right.
He took that as she's working on it.
Right,
but he let her take the initiative to work on it.
And I think he did that because he knew from past experience that if mom didn't make this, if mom wasn't the one making the decision, or if he were to say,
it seems like then he should have made his decision more forthright.
Yeah, he would not have been, if he had said, we're going to go to St. Mary's, she would have said, no, we're not. We're going to go someplace else. He knew that. He wanted to work with her. And there were places with a waiting list. But this process really started like in February.
But it was August when the final decision was made, and it appeared that St. Mary's was the only one that had availability.
Correct, and
school starting in a couple weeks.
That's very true. And he had begun asking her, when can we talk about this, in February? And her response and her testimony at court was, well, they said they had waiting lists at the other schools. put your kid on the waiting list. Discuss with the father, would you like to put the child on the St. Mary's waiting list? Would you like it to be at the Hamilton College wait list? Whichever. But she did not respond and said, I'm working on it until it was down to the one she wanted.
That was the one that was the only one that was left.
That's the only one that was left.
Well, thank you, Counselor. And if there's anything we could say is we hope these people learn how to get along a little better for the sake of their child.
I think if we can all agree on that, and I think that they are.
Thank you very much. Sir?
Oh, thank you, Your Honors. I'm Scott Otis here on behalf of the child. Luckily, despite the party's shenanigans, she does have a close relationship with both her parents. And that's a strong truth. I have to say, I think it seems like the court has a good beat on the underlying issues. This alternating year scheme wasn't even what the father asked for. He did ask for separate spheres of decision making, and I don't think that would have been objectionable. But to switch them back and forth every year, especially with these parties, the child's best interests don't change year to year at the start of the calendar year, such that they should be subject to a different person's opinion. And so I really think the trial court should have made a choice rather than whatever efforts they may have been undertaking to educate the parents or to cause the parents to get along better. Ultimately, none of those are the point of family court, but rather the child's best interest. And switching back and forth the decision making each year just can't be a good scheme, and it shouldn't be precedentially allowed, because it's going to just create a lot more heartaches for these folks in the future. I also agree with Appellant on the contempt charge. There was no clear, unequivocal mandate in the order that was violated. And so I felt like it was improvident of the trial court to issue that. The child obviously doesn't have the child's own appeal in on that issue, but I would side with the appellant. I really don't have much more for the court beyond what I've put in my brief, unless there are questions.
I think
Is the kid enrolled in kindergarten? Were
I
they able to?
No, I'm not sure if the child has yet been enrolled. I believe that issue was taken care of, but I can't testify to that. I'm sorry.
Thank you.
Okay.
Thank you.
Thank you. Case number 555, McLaren versus Whitehead. Which is also, case number 556, 557, 558, 559, 560, 561, 562, 563, and 564.
Yes.
All right.
Thank you, Your Honor, but I'll just be here for a few minutes because it's one big case, which I had consolidated. I'm Charles Greenberg, representing Letitia McLaren in this matter. And this is actually legally a very simple appeal, because the only question. One issue is whether she had standing. And I did cite some two cases from the case law that would state that you can be roommates, that intimate is not the same. Does not have the same definition as sexual. So two people can live together as roommates and be in an intimate relationship for the purposes of section 813, subparagraph E, and still have standing in family court to litigate for family offense petition.
Counselor,
Yes.
I understand that argument. My question is whether that argument was made before the family court.
Well, the lower attorney didn't really cite that specific section when he opposed it. So, I mean, I don't think it was made with the type of specificity right down to the.
He didn't say they were in an intimate relationship.
He just opposed it. I think
he just opposed it.
Yeah, well, on very general terms, unfortunately. He didn't refer to the two cases I cite. I mean, I think his entire, I know the record didn't bring the record with me, but
Right.
I think if memory serves, I think.
But if he had, it might have triggered the judge and maybe even had a fact-finding hearing on this.
That would be correct.
Right.
Yes. I think if the trial attorney had said, here are the two cases, I mean, but there were other cases he could have cited as well, but I cited the two that I thought were most appropriate for this case. But had that been brought to the trial judge's, to Ms. Brinkworth, I'm sorry, not Ms. Brinkworth, Judge Brinkworth's attention, then that certainly would have Might have changed the game down at the trial level.
Okay,
Thank you.
Ms. Talman?
Thank you. It's my position on my client's behalf that even under such a definition of intimacy, that these parties would not qualify, that this is my client's sister, who was only residing at the residence, not in any relationship to the father, but in relationship to her mother. And so that there was really no relationship between the petitioner and the respondent. From my client's perspective, she, to the extent that it's relevant, she stayed with her father throughout these proceedings throughout every, iteration of the proceedings where he was out and then back in the house. It was, from my perspective, these applications before the court were about the real property, and that was really what was at issue in IDV. That was not before the court in family court, but that was ongoing throughout the applications in family court. That's what was ongoing in IDV, was whether or not the mother and this older daughter, the petitioner, had the right to stay at the property. And so from my perspective, that was the intent of these filings, not having anything to do with the relationship between the petitioner and the respondent herein.
Okay. Any questions? Thank you, Ms. Donnelly.
Thank you.
Okay, number 567, New Vine versus Barzy. Okay, good morning.
Morning, Your Honors. May it please the court. John Grisky for the plaintiff appellant Mitchell Newvine. Your Honors, I believe I pretty much mapped out this course in our appeal in my papers, my submissions. The basis for the appeal is namely that the court improperly charged the jury with TJI 214, because the emergency doctrine. To be a qualifying event for an emergency, there needs to be something that is sudden and unforeseen. Now, as the testimony shows throughout this trial, there was nothing sudden, there was nothing unforeseen. The defendant himself testified that he first observed the plaintiff approaching him from about 588 feet away, and that he kept his eyes on him that entire time, up until the very point of the collision, when the defendant took a left-hand turn and the plaintiff collided with the side of his truck in the westbound lane, so in the plaintiff's own lane of travel. The second basis of the appeal is that verdict must be set aside as being against the weight of the evidence. The testimony from the defendant himself, as the plaintiff didn't recall any of the collision, ultimately set him up saying that he violated different portions of the vehicle and traffic law. In making the left-hand turn, it's clear that it wasn't reasonably safe to do so when
But if the emergency doctrine applies, then we don't need to consider those violations, correct?
No, Your Honor. So if the emergency doctrine does apply, the defendant or the party who has requested that charge can be held negligent if the response to whatever emergency it might be was not reasonable and prudent. Now, here we have a bicyclist which is approaching a pickup truck. The defendant was not in any danger.
He's crossing the center line, comes into the defendant's line of traffic. Peter said he's moving over to the south shoulder.
The defendant testified that he presumed he was going to the left hand to the other shoulder.
He's moving that direction, correct?
His testimony stated, especially on cross-examination, that as he came off from Mitchell Ave and turned right onto East Malloy Road, going westbound and approaching the defendant, he saw him momentarily cross over the center line and then immediately move back into the other lane. So just as you can presume a bicyclist moving in the opposite direction of a truck or a vehicle approaching them.
Bicyclists have to abide by these rules, V&T rules. He's got to stay in his own lane.
Yes, he does have to apply.
He's moving over the center line. He's kicking up his feet. He's got his feet off the pedals.
That was the testimony, but it's clear from the testimony that the plaintiff himself on his bicycle was moving back into his own lane, given the point of the collision itself, which was in the westbound lane, the proper lane for him to be in, and close to the fog line, almost onto the shoulder of the road. And that is the testimony from the defendant. So it's clear that the plaintiff was moving back into his lane of travel to avoid this pickup truck he saw approaching him.
Counselor,
Yeah.
isn't that, I think what the defendant's argument here is that if the emergency doctrine applies, then any type of evasive action that the defendant may undertake here to try to avoid the accident has to be viewed through that lens, even though it may have been a mistake or a misjudgment, but it was done under those emergency circumstances. Right? And that's the jury question, isn't it, Counselor?
I think specifically we have to look at the part of the emergency.
Because the jury could see it your way. The jury could say, well, that would not have been reasonable even under the emergency doctrine, but the jury, in this case, viewed the evidence in another light, didn't they?
Not necessarily. Where I think the court improperly charged them is saying that this occurrence was sudden and unforeseen. Sudden unforeseen means there's little or no time for thought or deliberation. Now, the defendant himself, he was returning to the Mattydale Fire Department where he would go down East Malloy, take a left. And that's exactly what he did. He never changed his mind. He never made a choice in a split second. He did exactly what he was going to do. And sudden unforeseen would mean that the vehicle crossed over immediately, leaving them no time to make any choice. But that's not what happened here. He watched him traveling down the road for nearly 2 football fields and kept his eyes on him the entire time. That's not sudden. It's foreseeable that if the plaintiff on his bicycle crossed into the oncoming lane, that he's going to cross back into his own lane to avoid this vehicle that's approaching him. So it's our contention that it was an improper charge based upon the fact that it was not sudden, it was not foreseen. There was no qualifying event that would warrant instructing the jury that way. And we can see that.
You don't think there's any view of the evidence that in the record to any of those items?
Based upon our second point of view, which it should be set aside because the defendant was per se negligent of the VTL, the jury never reached the question of whether or not the defendant's negligence was a substantial factor in the collision. So any contributory negligence, they didn't even reach that. It would be a different scenario if they said yes to the first question and then said no, his negligence was not a substantial factor. So looking at that, we have to kind of look at both there. But with regard to the emergency doctrine in the 4th Department, it is reversible error if the emergency doctrine is improperly charged. I believe that's Kizis Riviera versus Nearing 2783D 1106. We can see the effect that the emergency doctrine had on the jury. So during the deliberation, the jury returned a question. And that question was essentially some form of, they wanted to hear the instruction about negligence and surprise. Now, after speaking with the judge and defense counsel, the judge decided to read the emergency instruction to the jury again. And after that emergency instruction was read to the jury again, it was a very short time thereafter that they came back with a verdict of no negligence for the defendant. So that improper charge influenced the jury, obviously adversely against the plaintiff. Any further questions?
No, I think we understood
Thank you.
your argument, counsel. Mr. Miller?
Thank you. May it please the court. The emergency doctrine, it's not a high bar to get it charged. There certainly is a reading of the facts that would at least get this charged. This court has gone all the way back to Gucci versus Gill, saying that crossover accidents, that's part of the emergency doctrine. As Judge Montour had mentioned, this was a case where this bicyclist was still in my guy's lane at the time my guy decided to make an early. He didn't make the left-hand turn when he originally wanted to. It was, I'm getting the heck out of Dodge now. And at the time he makes that left-hand turn, the bicyclist is still in our lane, heading towards the south shoulder.
And he actually follows my guy across the road. This isn't something where my guy took a left-hand turn in front of him. Now, the emergency doctrine, you read the language, it gives the jury a choice. They're the ones who get to decide whether the emergency doctrine actually applies. The court just merely has the threshold of, is there enough to get it to the jury? There is oodles of evidence in this case.
Can I ask a question?
Yes.
Okay, so there was a little bit of discussion about the fact that we're talking about a pickup truck versus a bicycle, and that the bicycle may not be able to surprise the truck with its maneuvers and things it was doing out there. Can you talk about that?
We are always surprised by bicyclists. We have, with our case, our dockets are littered with motorists that were surprised by bicyclists that entered the road or were traveling along the shoulder and ducked out or weaved. In this particular case, my guy was absolutely surprised because this was almost a continuing emergency. My guy had to guess what this guy was going to do. It was suggested in the appellant papers that my guy should have just stopped. Well, how is my guy going to know that this guy who's on a motorized bicycle?
Okay, so it wasn't a bicycle, it was a,
The estimate of the speed was around 20. Now, I don't know if any of you ride, I do. I can't ride 20. 20, you got to have a motor running. All right. So, and with his feet up on, up in the air, how is it being propelled if not for the motor? But they're closing at 40 some miles per hour at this point. Regardless of where my guy sees him, it's a constant guessing game. What's he doing? Okay, he's weaving across the double yellow line. Now he's in my lane. Now he's heading this way. If he stops, he's got to guess that this guy is going to recognize that there's a problem. We find out afterward he's 3 sheets to the wind.
Counselor, the e-bike hit the passenger side of the truck, correct?
Yes.
What lane did could you just help me out again?
It was actually over on the shoulder. What happened was, as I said, my guy, when the bicyclist is in our lane and actually heading towards the south shoulder, my guy determines, I'm heading this way anyway. I'm normally going to take my life here. I'm just going to cut this corner and get into the parking lot. It's a wide part. It's not like there's just a curb cut. It's a very wide parking lot. So I'm going to go this way. Well, as my guy, makes that left-hand turn, this guy decides
he's coming back.
Now he starts coming back. My guy never sees it because everything's happening. My guy's already making his turn. Everything's happening behind him now. And the motorized bicycle follows him across the road. So it's never a matter of my client making a left-hand turn in front of him. He follows my guy across the road and hits the back end of our pickup truck. So, I mean, I don't know how, even without an emergency doctrine, I don't know how a jury ever decides for the plaintiff. There's no violation here because at the time we made the decision, there was no hazard in that lane. So.
I think we have your argument.
Thank
Thank
you
you very much.
All right.
Okay, case number 568. Pace versus Krausfeld. Okay, counsel?
Good morning, Your Honors. May it please the court. Here today on behalf of Dr. Bradley in support of his appeal from the decision and order that denied in part his post-trial motion in this medical malpractice case. The arguments before the court essentially fall into 3 different categories. There's a legal sufficiency and weight of the evidence argument, interest of justice arguments, there are several of those, and then damages. With respect to legal sufficiency and the weight of the evidence, those issues fall into 2 different categories. There is the time that Mrs. Pace was at upstate rehab and Dr. Bradley was present at work from June 19th to July 3rd. The second category is what happened when Dr. Bradley left to go on vacation. And that involves the July 4th x-ray and the time after that, when she was still at Upstate, but he was not there. And with respect to that first category, it's our position that the evidence was legally insufficient. The verdict was against the weight of the evidence because a physician who was not qualified to opine regarding the standard of care for a physiatrist gave testimony that had no medical or factual basis. We go through
Isn't counsel the usual rule about expert testimony in medical malpractice cases is that a doctor can testify about what another doctor does? And it's a weight question?
Typically it is, Your Honor. But here we're talking about orthopedic surgery versus physical medicine and rehabilitation, which are two different specialties with distinct training and board certifications who provide different care in completely different settings.
But they often work together, especially in a hospital setting like this.
They do sometimes. And the real issue from our perspective with respect to Dr. Wetzler was even if he was qualified, he gave no evidentiary foundation for the testimony that he provided. He gave testimony against Dr. Bradley on 7 pages of the trial transcript. And in the record on appeal, it's page 416 to 423. And it was all conditional. If she showed a decrease in mobility, if she showed increased pain, then an x-ray was required. Well, did she? Dr. Wetzler never said. The only person who made an attempt to say was the plaintiff's attorney in his closing argument.
And wouldn't those facts be borne out by the medical record?
That's the argument I think that the plaintiff makes, Your Honor, but there's a difference between referring to facts that are in a medical record as an expert and inviting the jury to act as its own expert, which is basically what the plaintiff did here. With respect to the second category of allegations against Dr. Bradley, the plaintiff has conceded that those allegations are meritless. In the post-trial motion briefing, the plaintiff conceded that Dr. Bradley had no duty to do anything in response to that July 4th x-ray because the evidence was unrebutted that when nurse practitioner Brown called him, she said it was normal. The plaintiff conceded that if the jury only found Dr. Bradley liable with respect to that x-ray, at that point, she already needed the hip replacement surgery, which narrows the possible damages just to that 10-day period. And the plaintiff wants this court to affirm the ruling on the decision in order, while at the same time admitting that the allegations that they put in front of the jury, that they opposed our motion for a directed verdict literally mere hours before the jury was charged, somehow doesn't fatally undermine this verdict.
Well, the jury found your client to be negligent here.
Correct.
And so if Dr. Wetzler's testimony is credited, then the jury got it right. I mean, in terms of what the jury was asked to do. I mean, there may have been some circumstances under which your client wasn't negligent, but there certainly were here, if you follow the evidence and you credit Dr. Wetzler, a theory of negligence for your client.
Well, I assume Your Honor is referring to the July 4th x-ray. The problem is that the plaintiff had to ultimately concede that that allegation had no merit because Dr. Wetzler's opinion that Dr. Bradley was required to do anything specifically hinged.
What you're asking for here is, yeah. But there is a theory here. I mean, even if the plaintiff concedes that fact, there is a theory here that the jury could have followed to find negligence as against your client.
I think that we're talking about 2 separate periods of time. And with respect to the July 4th and on, no, because Dr. Wetzler's opinion that there was a deviation hinged on Dr. Bradley having been told that the x-ray was abnormal. The only testimony in this case was that he was told it was normal. So there's literally not a single shred of evidence to support liability against Dr. Bradley with respect to the July 4th x-ray. And even the plaintiff admitted that Dr. Wetzler didn't identify any alleged deviations from the standard of care after that x-ray. So we have a case where the plaintiff has made these concessions. And it's our position that under Davis versus Caldwell, because there's insufficient proof for one or more of the plaintiff's theories, it requires a reversal and a new trial on the theories for which there's arguably sufficient proof. Also,
Go ahead, just.
At the time that these theories were posed to the jury, there was more than one defendant on trial, okay? So but the jury only found your client, negligent. Correct. All right, so there's no wrongdoing by proposing that the jury find one or more of the defendants negligent on one or more of the theories, is there?
Well, Your Honor, the question is, how many theories did the plaintiffs offer against Dr. Bradley?
Well, we said that there's at least one, that there would be a line to follow that would get to the answer that he was negligent, okay? So why isn't that enough here?
It isn't enough here, Your Honor, because we requested a special interrogatory.
Okay, let's talk about that.
Yes.
Because that's really what this case is about, right? And it's not about these other things. It's about what did you do to ensure, and I don't mean you personally, I don't know if you were trial counsel or not. Okay, what did you do to ensure that the jury would answer the question that was pertinent to your client?
We requested a special interrogatory.
And how did you do that?
During the discussions and the objections and the arguments for directed verdict.
Okay.
At the close of the plaintiff's case, which because of the way this trial was carried out, was literally done on the last day of trial. We asked for a special interrogatory that said, if you conclude that Dr. Bradley, and at that time, Dr. Hames, was only negligent with respect to the x-ray, you can only award damages from July 4th to July 13th. Essentially, what we asked for was a special interrogatory that would have made it possible to determine whether the jury based its verdict on a theory that the plaintiffs have since conceded has no merit.
I look back in the record and Judge Antonacci here had pretty clear trial rules. Verdict sheets were required to be submitted 1 week before trial. Was a special verdict sheet requested at that point?
It wasn't, Your Honor, but at
Was
that
a special verdict sheet requested before the jury was charged?
it was before the jury was charged.
There was a
yes.
special verdict sheet? The specific questions were they presented to Judge Antonacci for him to rule on as to whether or not those questions would go before the jury?
Not in writing, Your Honor. The request was made in this section of
During argument.
during
During
our,
argument on the motion for directed verdict, there was I mean, someone might read this as just a suggestion. I mean, in advance, the suggestion sort of in one way of interpreting it is that it bolstered the argument as to why the court should grant the motion for a directed verdict, as opposed to requesting a special verdict as it related to what was indeed going to be instructed to the jury.
I think that they were intertwined, Your Honor, and this is the reason, is that the plaintiff opened with a lot of different
Let me
allegations.
stop you there for a moment, because here's where I'm having difficulty with your argument. When the judge does charge the jury and he asks all of the attorneys, he marks the verdict sheet as Court's Exhibit A and asks each and every one of the attorneys, is this verdict sheet acceptable? And what does counsel for Dr. Bradley say?
In the presence of the jury, it was acceptable in that it reflected the court's prior rulings and was accurate.
But right. Was there an objection made?
There was an objection made during the colloquy that we're discussing. Counsel put an objection on the record.
What's the objection on the record? What page in the record for the objection to the general verdict sheet?
Pages 1534 to 1536.
Right.
Counsel placed an exception on the record, and it's our position.
Well, show me, I'm sorry, I'm looking at 1534 to 1535. I've looked. What does Mr. Madison say in terms of an objection to this verdict sheet?
He asks for the special interrogatory that says, if you conclude that these defendants are only negligent with respect to the x-ray, you can only.
I see that. I'm sorry, press you on it. I see that. But where does he object to the verdict sheet? You said he objected.
That we believe is tantamount
That's
to
the
objection. Correct.
Okay.
And at the
So if you just let me dovetail here. So there was no attempt to give the judge a piece of paper that said, we think you should do this instead. Okay. There was nothing like that.
Correct, Your Honor, which is we respectfully submit is not required under this court's case law.
Okay. There doesn't seem to be enough of attention drawn to this issue by counsel for your doc, okay? In other words, once they discussed and decided on their directed verdict that there wouldn't be one, from what I could see in the record, the issue just dropped. There was no objection made to the verdict sheet or the charge, in my view. There was that one discussion, that Justice Del Conte brought to our attention, but besides that, there's nothing.
Well, and if Your Honor so concludes, that still does not defeat our argument, because we respectfully submit that under this court's decision in Brighton, this is an error so fundamental that it precluded the proper resolution of this case. The plaintiff put forth a number of different theories, opposed our motion for a directed verdict, opposed when we asked for this question on the verdict sheet. We go to verdict, we make a motion to set aside, and the plaintiff concedes that some of the theories that it fought until the very last day to get in front of the jury by then had no merit. And this is the kind of error that fundamentally undermines the verdict.
Okay, and which I would suggest to you, if that was so, I might have expected a little more attention being brought to it, a little more jumping up and down, but Your Honor, we must do this, blah, blah, and I don't see that. But you're saying that that's not necessary.
I submit that it was done, and if it wasn't necessary, because this sort of post-trial admission renders this such a fundamental error that a new trial is required. We also have asked for a new trial on a number of different interests of justice grounds. The Stryker document, the operative technique, I think the court can see that the Supreme Court recognized after it made this ruling that the ruling was incorrect. Dr. DiGiovanni clearly and ambiguously testified that he didn't consider it trustworthy. His testimony as a whole establishes that he didn't consider it trustworthy, reliable. It was not the standard of care. The court recognized the error by basically saying he would sleep better if nobody talked about it again, and barred the plaintiffs from referencing it in their closings. But the plaintiffs have really never disputed the Supreme Court's characterization of this as a pivotal point in a key ruling that went to the ultimate issue. And so, therefore, this is not harmless error. It requires a new trial in the interest of justice. We also had an extremely rushed trial. I won't go through all of the different things that happened, but I think that it's far more than just the cherry picking that the court mentioned in its decision in order. It was a pervasive pattern of taking shortcuts and doing things out of order that really prejudiced Dr. Bradley. The best example of that, which is a grounds for reversal in its own right, is the fact that Dr. Bradley was forced to conduct his entire cross-examination of the only witness who offered any testimony critical of his care under circumstances that the court agreed were not ideal, when the plaintiff had the opportunity for a full and problem-free, live, unrushed, direct examination. And we know that courts have the discretion to allow testimony to be taken by teams. I mean, that's not our argument here. It's the inequity here, that it was unnecessary. It only benefited a paid expert witness, and the technological problems that occurred were not ideal, and they significantly prejudiced Dr. Bradley's ability to defend himself. And that this error was not harmless because the plaintiff tries to make an argument in his brief that basically every expert offered testimony against Dr. Bradley. So anything that was precluded with respect to Dr. Wetzler or problematic was harmless. And that argument is just false. Dr. Wetzler was the only expert against Dr. Bradley. We also had a juror sit on the panel who knew Mrs. Pace. He was grossly unqualified to sit. He should have been removed. And even if it was an error to remove him, it was error not to conduct a probing and tactful inquiry and to discourage the defense attorneys when they asked for additional questioning. Because if the court doesn't conduct that tactful and probing inquiry, any conclusion that that juror is not grossly unqualified is speculative, and that's what happened here. There was also the inherent prejudice of the fact that this juror knew Mrs. Pace before, and that was the plaintiff's entire argument on damages, was that she was different than she was before. With respect to damages, the plaintiff has cross appealed and argued that the court erred when it engaged in remitted at all, and that the court, that the
I think it's our understanding there was another subsequent trial on damages.
there was, correct, Your Honor.
Okay. So does that matter?
It was significantly, Your Honor. We have made a motion to dismiss the plaintiff's cross appeal under the Court of Appeals decision in Oaks versus Patel, which says if a party wants to challenge a remitted, they have to do it before damages is tried again. We argued that these appeals should proceed before the second damages trial. We made multiple attempts to get a stay. The plaintiff opposed those attempts. And it's our position at this point that under Oaks, it's black letter law that the plaintiff's cross appeal from the remitted has to be dismissed. If this court doesn't agree, I think it's very well established that this was just a runaway verdict. $5 million for 6 years of pain and suffering for a hip injury and $2 million for loss of consortium. I mean,
what was the verdict on their rehearing on damages?
it was a total of $1.55 million. It was basically, for all intents and purposes, the same amount as Justice Antonacci's remitted. So if this court doesn't dismiss the cross appeal, which we submit as required by Oaks, this would have been the highest verdict basically in the state for any of these injuries by several orders of magnitude. And therefore, it was proper to engage in remitted.
Thank you, counsel. Counsel, you have to unmute yourself. There you go. Okay.
Good morning. Thank you. And may it please the court. Jordan Ray David for Mr. Ronald Pace individually and also in his capacity on behalf of his late wife's estate, that's Geraldine Pace. I'd like to begin by starting with our opposition to Dr. Bradley's appeal. And let me just point out on the issue of liability, although my colleague on the other side does acknowledge it's a legal sufficiency analysis, the case law also uses the framework of whether the jury's decision on liability was utterly irrational. And under that standard, there's no reason for this court to grant Dr. Bradley a new trial on liability. The second thing I'd say is this court is correct in some of its comments, and my colleague in its brief is as well. There were multiple defendants that proceeded to trial in the first instance. Therefore, multiple theories of liability were espoused by the plaintiff. There's no preclusion under the case law for that. But as it specifically relates to Dr. Bradley, who's the pertinent litigant that remains on that side of the aisle, there is some confusion by my colleague on the other side that I want to clarify. And it seems like the court has grasped it, but in an abundance of caution, I'd like to specify it. This notion of the July 4th x-ray, whether it's normal or abnormal, is a bit of the cart being ahead of the horse. The reality here is that Geraldine Pace came into Dr. Bradley's care in June, already having a hip fracture that was surgically repaired. The theory espoused against Dr. Bradley for liability purposes was that by Dr. Bradley pushing Geraldine Pace too hard, too soon, specifically meaning putting her on full weight bearing, without evidence of healing from the prior surgery, it caused a catastrophic failure of the prior surgery. That failure had already taken place, meaning quite literally, the deviation from the standard of care and resulting causal damages had already cascaded and begun to fall like dominoes well before that July 4th x-ray. So the very notion that Dr. Bradley argues even to this day about this 10-day period should have been cut off, it's really missing the forest for the trees. The jury got it right based on the actual evidence that was presented to it, which is namely, Dr. Wetzler explained how post-operatively for Mrs. Pace, when she came into Dr. Bradley's care, Dr. Bradley should not have had her on full weight bearing as tolerated unless there was evidence of healing of the fracture, which usually takes multiple weeks and is supposed to be.
I don't want to distract you from your train of thought here, but that seems to me what you just explained to us is how Judge Antonacci interpreted the motion for directed verdict in terms of that question that was posed, that it seems to me that the question can be interpreted that we want to cut off damages, that Dr. Bradley shouldn't be, even if you agree with the theory presented through Dr. Wetzler, that Dr. Bradley wasn't responsible for the patient after July 4th. Because clearly the issue at the x-ray was it showed that there was indeed a protruding hardware on July 4th.
I think I understand your comment. I will start by saying Judge Antonacci got it right below on that particular analysis. And I think that the disconnect between the parties here, but my side is correct on, and Judge Antonacci was correct on with respect to that issue, is Dr. Bradley is essentially arguing, okay, even if I committed malpractice and then this July 4th imaging study proves it, like actually shows here's the subsequent change in the medical condition, then I'm off the hook for damages entirely. Dr. Bradley frames their argument on damages as saying, we think it was only 10 days versus the rest of her life. The reality is what they're really saying is, even if Dr. Bradley caused this catastrophic device failure, we don't want to be on the hook for any damages. When you zoom out of this and you look at how the jury got it right, Judge Antonacci got it right, and how we argued on our appeal, the moment the device fails as a result of Dr. Bradley's deviation from the standard of care, he is on the hook for all of the resulting causally related damages. That is, Dr. Bradley called it a complication from the first surgery. The jury disagreed in accordance with Dr. Wetzler's testimony and the overall medical evidence here. He was on the hook for all of it. And when we come into the damages picture, which for our purposes is cross-appellant, I do think is critically important, there's two things that I want to say. First, in addressing Judge Bannister's question about, well, there was a second trial, so what do we do of the cross-appeal? Does that kind of render it moot? To which Dr. Bradley says, of course it does. I disagree, and I disagree based exclusively on the fact of Oaks versus Patel does not call for that. And secondly, it would be illogical and manifestly unjust to do so. Let me unpackage this just for a bit. We are in a situation in this case where the first reversible error, in our view, doesn't occur until after the December 2023 verdict of $7 million is returned, and then Justice Antonacci grants remittitor. It is at that point that the first reversible error, in our mind, crystallizes. Now we look to Oaks versus Patel because this is a remittitor additor kind of decision, and that's the best case on point. What Oaks versus Patel was concerned with is a party who disapproves of an additor or remittitor decision not perfecting their appeal, rolling the dice on a second trial, then only after the second trial saying, wait, just kidding, I want to appeal the outcome from the first. In that case, Oaks, it was a defendant not liking additor, saying nothing of substance, meaning not perfecting an appeal, proceeding to a second trial, then being like, whoops, I don't like both bites at my apple. Here we have a materially distinguishable procedural posture for this court, which is why Oaks Patel, this court doesn't have to rule that it doesn't apply or that it's distinguishable in some material way. It just simply doesn't fit. Here, Mr. Pace was faced with a remittitor order by Justice Antonacci that said, either accept the remittitor or proceed to a second trial. But unlike the defendant in Oaks, Mr. Pace said, I am perfecting my appeal because I don't think you should have granted remittitor at all. Appeal perfected, then proceeds to trial 2. And if we look at the specific nuances of this case, I think, look.
Well, let me ask you, why did that happen? Why, if you didn't want that to happen, I mean, did you ask the judge to slow it down so you can get your appeal heard? Or what? Like, how did that happen that there was another trial without this appeal coming first?
You and I intersected each other right where I was going to take the court. There are many scenarios where cases can seem analogous and kind of fit into the same bucket and just say, this is an Oaks Patel situation, this is how it should come. Mr. Pace's situation is unique, and I hate to be morbid, but from a mortality standpoint. We already lost Geraldine Pace during the pendency of the underlying litigation before trial 1. Now, after trial 1, we take Mr. Pace as he stands, which is, I believe at that time, an 85-year-old man, in good health, all things considered, but the prospects for Mr. Pace in a very literal sense were as follows. I don't want to accept Justice Antonacci's remittitor, and I'm willing to perfect my appeal, and I have now done that. Must I now sit and wait 18, 24, perhaps longer months for this court, the Fourth Department, despite its best efforts for its efficiency, to render some decision? He may no longer be with us. Therefore, he did what the law permits and what logic should support, which is to say that in this particular case, and I think the court could write the opinion this way, on these specific facts, where the surviving plaintiff that remains is of such an age where statutorily under New York law as a general concept, they should be getting pushed their dockets. As long as he perfects his appeal after the first remitted order, cementing that he doesn't like it and he wishes to challenge it, we're not going to punish him by being economical with the court and frankly his own limited time on this earth by proceeding to a second trial. But as sometimes happens in the law with jurisprudence, this case is even more unique than just that. It happens to be that in the second trial, and there's a pending motion for a new trial on it begrudgingly, the woman who sat as foreperson, the very first juror selected, is married to a physician who went to the same medical school in Grenada as Dr. Bradley, worked at the same hospital where Dr. Bradley was found negligent with my client, and is being sued in 4 different medical malpractice cases, including 2 actively pending before Justice Antonacci currently, and never disclosed any of that. Worse yet, in the juror questionnaire that was presented to her, the very question that says, is anyone in your family or close, network, have they ever been sued for any reason? She checked no. And then over 2 days of voir dire, never brought that to anyone's attention. So in a very unfortunate circumstances, it's almost as if the second trial didn't exist because of juror misconduct. But we're not here on that. I'm just giving the context. This court on the remittitor analysis as cross appellant, I want to offer my position. I would ask this court to exercise restraint from looking at a pure, cold, calculated medical diagnosis. And here's what I mean. My colleague on the other side frames all of this issue on remittitor by saying this is a hip injury case or it's a hip fracture case. It is not. Human beings are far more complex than that, and damages are more of a mosaic than they are a singular tile. Mrs. Pace fell in a parking lot, fractured her hip, went to Krause Hospital, and had it repaired. At that moment, she was on the path to recovery, and she should have been fine. The reality here is that Dr. Bradley's negligence, medical negligence, caused a catastrophic device failure. If you look at Dr. Weiss, the first surgeon's testimony in trial 1, he says the second surgery was 100 times more severe than the one that he performed. If you look at Dr. Sherman, Robert Sherman, who's the actual surgeon for surgery 2, after Dr. Bradley's medical negligence, he says it was a limb salvage operation. But let's not just stop there. We don't look at damages to say what CPT code or medical diagnosis will the doctor prescribe. Damages, especially in a case like this where we pursued purely non-economic damages for the late Mrs. Pace's estate, we have to look at pain and suffering for what they are, which is not just a medical record. The testimony here was this woman could not bathe herself, could not use the bathroom herself. Her husband had to help her. She went from active, dancing, walking. I think Mr. Pace's exact and most powerful testimony for this jury was, it was like the sunlight got extinguished and never came back. She transformed. Mr. Pace said that the woman he married of 50 plus years of marriage died essentially as a result of Dr. Bradley's care in a meaningful sense and never returned. The jury looked at all of the evidence and decided, and by the way, a jury based of Onondaga County residents. I think a lot of the undertones of Dr. Bradley's arguments are look at the whole state, or essentially implying these are supposed to be downstate numbers, not upstate. I reject that premise as repugnant. Onondaga County citizens sat, they listened to all the facts, they read all the records, they decided that $7 million total for both plaintiffs was appropriate. Now the analysis is, let's look at Judge Antonacci and ask what was he expected to do under the law, because remittitor is not obligatory even if every defendant asks for it. The reality is remittitor is only appropriate when there's a material deviation from some standard. And as the movement, Dr. Bradley had the burden to establish that standard and couldn't. I would argue that there is a disproportionate correlation between the number of cases a movement for remittitor cites and the persuasiveness of their case. If there was a case that showed a woman of a certain age and a certain pre-fall active lifestyle as a result of medical negligence becoming essentially wheelchair bound, the sunlight being extinguished forever, and her husband having to take care of her for the rest of her life, Dr. Bradley would have cited it. Instead, he cited the cases with mild fractures. He cited a case where a person was already wheelchair bound and had dementia, fell out of their wheelchair, but then was generally fine, so on and so forth. Our position is that Dr. Bradley didn't do enough for Justice Antonacci to even breach the remittitor in the first instance. So what are we asking for this court today? We are asking for the court to find that the only error that took place leading up to and following trial number 1 was Justice Antonacci granting remittitor. This jury got it right, and Dr. Bradley didn't meet his burden to warrant that reduction. Therefore, the first verdict of $7 million should be restored, full stop. If that were to be done, my client accepts it, the judgment is done, the second trial is what's rendered moot by a matter of practicality. The alternative, which I hope this court doesn't need to engage in, is to simply say the reduction from $7 million all the way down to where Justice Antonacci put it is not based on any strong precedent that is factually analogous. It is a painstaking process for any judge. I don't envy the position of Justice Antonacci, nor any of you that I'm talking to today. But to say for the county of Onondaga that when people walk into a courtroom and listen to 2 weeks of testimony and deliberate for 8-9 hours, whatever it was, over the holidays, no rush at all, and come to this calculated decision of who's responsible and why, and what the value of that damages is worth, to reduce it more than 75% in the absence of strong factually analogous precedent is manifestly unjust. And unless there's,
We'll look at that, we'll look at that very carefully.
thank you.
Thank you. Okay. Case number 569, Page versus Rittersbach.
Please, the court.
One second.
I'm Paul Lloyd. I'm the attorney for Clark L. Rittersbach, the appellant. Clark L. Rittersbach is a man in his 80s. Clark P. Rittersbach, the other defendant, and Clark P. Rittersbach's business. Clark P. Rittersbach is the son of Clark L. Rittersbach. He's a man about 50 years old. The grandiose allegations in the complaint, which goes 50 pages in the record from page 37 to page 87, were all done by Clark P. Rittersbach, the son. Clark L. Rittersbach had nothing to do with it. He had no business relationship with Mr. Page, nothing. The only thing he did, my point one is on the conversion issue, was when Clark P. Rittersbach, his son, no longer maintained his business premises, the parts of the car, this is not an actual automobile. It's not a 1925 Silver Ghost that you could get in and drive. It's parts of a car. They weigh a lot. It's about 2,000 to 3,000 pounds. My client, Clark L. Rittersbach, in a storage unit, in a storage space rented by his wife, where they keep their boat and their lawn furniture and stuff, kept these car parts. He never refused to give them to anybody. When Mr. Holland, the investigator, came, my client had no idea who he was, and he's asking about these car parts. My client had none of the conversations with Rupert Page, so he didn't know what the status of storage was of the parts, what the status of car repair was, nothing.
Counselor, as I understand the record, sometime in January of 2022, your client contacts the private investigator and says that the guy in England can have the car parts.
I beg your pardon?
Your client contacted the investigator in January and said that the man in England can have the car parts.
Basically,
but your client didn't do anything and sort of dragged his feet, and they couldn't get the car parts for another 3.5 months.
He didn't have, first of all, you have to come with equipment to get the car parts. It isn't like, okay, I've got them in my pocket, I'll hand them to you. These are heavy pieces. They actually had missed one of the car parts. My client called them back and said, come with the truck. We've got a part that weighs at least 500 pounds. You got to be able to get it. My client didn't ever oppose it. It's just that you can't just hand these things over. It might take a couple months to get the right people there to pick this up.
When the investigator came, correct me if I'm wrong.
Okay.
They asked your client for his son's cell phone, contact information. I don't have that.
My client didn't have any idea who the guy was. So when this person comes to his door, he gets the person's contact information, contacts his son. And I think the son contacted the investigator, and I know my client also contacted him later. Ultimately, they did get the car back. It wasn't as a result of my client saying, no, you're not going to get it. It was as a result of the fact that this just simply cannot be moved without the correct equipment and the correct people. With regard to spoliation.
Was it your client who was trying to get storage fees?
No, his son was paid the storage fee. My client was paid nothing by Mr. Page at all. And my client didn't even know that Mr. Page had paid storage fees to his son. So that was part of it. At first, he didn't know, I think this guy owes my son money for storing this. That was, I think, something in his mind. But the bottom line is my client got nothing from him and wasn't looking for storage fees. With regard to the spoliation of evidence, as I mentioned, Mr. Clark L. Rittersbach is a man in his 80s. His cell phone died, the cell phone that he had at the original deposition. Counsel said, we want to look at your cell phone at the deposition. So we brought Mr. Clark L. Rittersbach and his cell phone back to their office, but it wasn't the same cell phone. His cell phone had a defect. It was no longer operable. I think it was Verizon took the cell phone back, gave him and Mrs. Rittersbach a new cell phone because both their cell phones essentially died. They didn't do anything to damage it. We have no reason to believe they didn't get all of the text messages they were looking for off of Mr. Rittersbach's phone, but we have an issue of spoliation of evidence. My client did not in any way, shape, or form intentionally deny them of any evidence. But I think the key point in this appeal is, if you look at the complaint, there's this whole grandiose scheme of the Rittersbachs, as they're referred to defraud Mr. Page of money. That simply didn't happen. Mr. Page's own
Well, that was
affidavit.
part of the reason why the plaintiff wanted those text messages.
Well, that's why.
In order to, to prove their theory here, that father and son were in constant communication, and father was just as involved in this endeavor with this.
But he wasn't.
Silver Ghost.
At 371 of the record, Mr. Page himself, in his affirmation that he made in, what's the date of it? I think it's 1982. 2022, I'm sorry, basically says, I never dealt with Clark L. Rittersbach. All my dealings with Clark P. Rittersbach. All my emails are with Clark P. Rittersbach. And when I didn't hear from Clark P. Rittersbach, that's when I got worried. And that's when I sent an investigator to look, to see. I thought there might be some problems. The other key issue, I think, is the very last document in the record on appeal. And that is at page, it's the very last document. It's Exhibit A of my affidavit in response, in support of my motion for summary judgment. That's the FBI investigation. The FBI didn't find that Clark L. Rittersbach got a dime from this. They traced all of the money in 3 fraud schemes that Clark P. Rittersbach had and brought federal charges against Clark P. Rittersbach for 3 fraud schemes. My client, Clark L., the father, is not at all involved in any of those. Basically, this case is a house that sits on sand. The sand is this conspiracy that didn't exist. And if the house sits on sand, it falls. This case has to fall on my summary judgment motion because it wasn't brought under CPLR 3211 as the court thought in this instance. I brought a prior 3211 motion because I thought this case was baloney from day one that I was involved in it. CPLR 3212 is what I brought this under. And if you search the record, you'll find no evidence against my client. The 2 major pieces that I cite in my affidavit are Rupert Page's own affidavit, where he says it sent all the money to Clark P. Rittersbach, not Clark L. And I dealt with Clark P. Rittersbach, not Clark L. And I emailed Clark P. Rittersbach, not Clark L. Rittersbach. He says it himself. That's the only sworn statement I have seen in over 2 years of litigation by Rupert Page, the only one. The FBI then investigates. What do? They don't charge Clark L. Rittersbach. They charge Clark P. Rittersbach, and they can prove, and they have in their paperwork, where every single dime of the money went, and none of it went to Clark L. Rittersbach. This case needs to end here. It needs to be dismissed on summary judgment, and that's the end of it. Clark L. Rittersbach, the man in his 80s, doesn't deserve what he's getting here. He didn't do any of this. Thank you.
Thank you, counsel.
Good morning, Asiya Ali from Adams Leclerc on behalf of respondents. I just want to raise a few points for support. First, with regard to conversion, plaintiffs have met their burden. They've made a prima facie case of conversion on January 6th at that face-to-face meeting with the private investigator on behalf of Page. The private investigator made a clear and effective demand to have an exclusive claim of ownership on behalf of Page. He had stated that he was seeking to locate and retrieve his vehicle, and instead, in response to that clear demand, Rittersbach Sr. had stated that he falsely did not know how to get in contact with his son, did not know where the vehicle was located, and further did not provide any information of how he can find the vehicle. counsel had previously stated that he otherwise did not know who the man was. However, the demand was clear. He knew exactly, albeit if he did not know who the man was, he knew exactly what property he was talking about, where the property was stored, the fact that there had been allegedly overdue storage payments on that same property. Who knew who the plaintiff was, and he knew that he had owned the property. So regardless if he had known that the plaintiff was there in person to make his demand or not, he knew exactly that from the context of the demand in and of itself, what exactly he was talking about, and still did not provide any information for access or facilitate any information on how he can go further retrieve his property.
Counsel, tell us about the cell phone and what the loss of the cell phone and the communications thereon meant in this case.
The cell phone records would be essentially evidence of communications between Clark L and Clark B as father and son. The fact that they had separate businesses, but it is a part of our general theory in our complaint that these two, the father worked to aid and abet his son in his fraud and his breach of fiduciary duty and failing to administer certain repairs despite the payment that plaintiff had made and promised for those repairs to be done. And further, in regard to spoliation, there was once again the court's April 14th, 2022 order that defendants had to maintain all records, including electronic records of transactions with plaintiff and records of communications and all business records concerning defendants' businesses and the business specifically operating.
Was the phone replaced after that order?
The phone was not replaced after that order. I mean, yes, it was, I'm sorry, replaced after that order. I believe 6 months had passed. And Rittersbach Sr. had testified in October later, and when he actually did appear, despite the due time that had passed for his phone inspection, that he had gotten rid of his phone on October 21st, 2022, which is 6 months from the court order. And I believe 4 months from plaintiff's 2 notices to produce and their notice of inspection specifically for electronic communications, proof of electronic communications through the cell phone. And upon the subpoena to Verizon on the records that had been on that phone that had been negligently disposed, is that there were scores of text message and call logs that could have been discoverable and could have been useful to plaintiffs in proving their claim of the aiding and abetting in fraud and aiding and abetting in breach of fiduciary duty with each other. But plaintiffs could not have access to that. And further, even after the countless discovery demands and the avoidance to appear for a cell phone inspection and produce responsive documents to plaintiff's demands and a court order, he still did not produce any production. He still did not produce his phone for inspection and any further documents that could further be responsive to plaintiff's discovery demands. And further, I'd also like to—
Let me, if my recollection is correct, when he did produce a new phone, I think it had like 94 text messages between the two.
Yes, it had, I want to say maybe a third of what had been indicated from the subpoena of Verizon of the original phone.
Wasn't it like over 4,000 text messages?
Yes.
Too? What time period was that from?
It was from March 2020, the relevant time period that we were alleging in our complaint, which was March 2021 and December 2021, where the entire time that we had stated that both Clark L and Clark B had been communicating with each other about the Rolls Royce, possibly the storage of the Rolls Royce, if it could have been possibly moved, because Clark L had testified that some time ago that the Rolls Royce had been moved to his storage facility in Bloomsfield that he had also testified to be using for years. And I'd also like to remind the court that the trial court has broad discretion in determining, if sanctions are appropriate, and if so, what sanctions are appropriate. And it's our position that the sanctions that were given were fair, considering the loss of evidence that we were not able to inspect and use for our claims.
Of those 94, was there any reference to the Rolls Royce at all?
Not that I know of.
So probably in those 4,000, there wasn't any either then, right?
No. And lastly, with regard to defendant's motion to dismiss, it was a motion to dismiss. In his papers, he had stated that it was pursuant to CPLR 3211. He had previously stated that in his papers that it was a motion to dismiss for failure to support our claims, the same rule that is stated under CPLR 3211A7. So the trial court did not abuse its discretion in relying on the assertions that were made in defendant's motion and administering a decision based on those indications that were indicated in his motion. And if the panel doesn't have any further questions, we rest on our brief.
Thank you, counsel.
Thank you.
Okay, case number 570, Frohoff and Chateau homeowners versus the town of Amherst.
Good morning, and may it please the court. I am Joshua Lippis, representing the appellant's petitioners. I would like to briefly highlight a few of the arguments from my brief and address some of the respondents' arguments. This appeal raises three central issues: whether the planning board violated the requirements of seeker, whether the planning board violated General Municipal Law 239M, and whether respondents violated the terms of the negative declaration and failed to obtain approval of the town's Historic Preservation Commission prior to demolition. As I stated in my papers, the town correctly treated the project as a Type 1 action under seeker, which presumes the likelihood of significant environmental impacts and the preparation of an environmental impact statement. Unfortunately, the planning board issued a negative declaration which avoided the preparation of an EIS. Petitioners argue that the record fails to show the planning board took the required hard look and provide a reasoned elaboration in some key areas as required by seeker. One key area is whether the project would impair the character or quality of important historical, archaeological, architectural, or aesthetic resources or of existing community or neighborhood character. The planning board ignored the admonition of the New York State Historic Preservation Office and the reasons why they believed the properties met the requirements for listing on the New York State and Federal Register of Historic Places, and issued no meaningful discussion on this subject.
Counselor.
Yes.
Did you argue that on the administrative level?
Yes, we did. Contrary to what the respondents said in their reply brief, this issue was raised in the lower court and was contained within petitioner's memorandum of law in support of the petition and rightly preserved to be heard by this court. That section of that document can be found in the record under 3400 to 3402 in the record. As I said, they offered no reasoned elaboration or discussion. Rather, they merely cited abbreviated facts concerning what they relied upon, but did not explain why the destruction of these buildings and replacing them with a modern, large-scale, mixed-use complex would not have a significant effect on the neighborhood or its historic character.
Counselor, correct me if I'm wrong. Wasn't the application for the preservation for the town historic, wasn't that after the negative declaration?
No, it was not.
They did applied, right? Or your clients applied and said we're historic.
First, they applied to see if it was eligible for registration, and the New York State Historic Preservation Office said yes, it is eligible, and here's the reasons why. Then they went ahead and applied for landmark status, which was still pending at the time the case was heard and decided, and still pending at the time the negative declaration was issued. And that wasn't the only issue that the petitioners had with the negative declaration. The other one, or the other main one, was that we believe they didn't take a hard look at the traffic and safety aspect as required under seeker. The planning board relied on respondents' traffic study, which was taken during the pandemic, and concluded no significant impacts, but that conclusion was never scrutinized. The board deferred entirely to the applicant's analysis and ignored community concerns about congestion, safety, and pedestrian risks. Just
aren't the buildings gone?
Yes, Judge, the buildings are gone, but what is going to replace them is still at issue. I know that the respondents have made much issue saying that this case is now moot simply because the buildings are gone, but that's not the case.
We can still, you can still consider the traffic, noise, safety of the neighborhood, et cetera. Can't those be in the final site plans?
Absolutely, those can still be considered, and that's what we are challenging, that they did not give a reasoned elaboration for their determinations regarding the traffic study, or the reasoned elaboration for why this mixed-use project, modern mixed-use project, wouldn't change the character of this historic neighborhood. The planning board offered conclusory statements as reasoned elaboration. They were inadequate to inform the public and other agencies for the reasons and factual support for the issuance of the negative declaration.
Which agencies weren't informed? It appears as though there were a handful of agencies that participated in this review.
They were informed of the negative declaration. They weren't informed of the reasoning that the planning board had as to why.
Didn't they review traffic studies, and Department of DOT reviewed it, the county planning board reviewed it? Who didn't review this stuff?
No, they sent it to review. I'm saying the reason elaboration aspect of seeker requires them to explain their reasoning as to why they came to the conclusions that they had. And what the planning board did was say, these are the documents and these are the people that were informed, but they never explained why, putting this large mixed use project in this neighborhood, this 1920s historic neighborhood, why that would have no effect, in their opinion, on the aesthetic nature of the neighborhood, and that, in their opinion, a negative declaration was warranted and an environmental impact statement shouldn't be created. A type 1 action presumes that a environmental impact statement should be made to inform the public of the other options that are had regarding the project, and other aspects that would come out of an environmental impact statement. Other than seeker, you mentioned that the Erie County Planning Department was informed of the project. This is correct. Under General Municipal Law 239M, the planning board must submit a full statement of the proposed action to the Erie County Planning Department. Although this was initially done in September 2022, the project was materially revised thereafter. The unit count was dropped, architectural features were changed, the site layout was altered, and none of these revisions or documents were resubmitted to the county, including the long form environmental assessment form, which was created after the initial submission.
But how do you know they were materially altered? How do you come up with materiality?
How do I know they?
Yes, how is it? How do you aver that it was materially altered from the first?
Based on what they submitted, and based on the documents that they submitted, including dropping the units, changing architectural features, changing the site layout itself, we believe that it was materially altered, and it should have required that it be resubmitted to the Erie County Planning Board.
You're saying such that your argument is such that the county then would have said, yeah, this is no longer just a local concern. Is that what your argument is?
It could have. We don't know that the changes may have changed their opinion. The alterations to the plan may have changed their opinion.
Such that it would go to a county level, not just a local Amherst level. That's what your argument is. I'm asking.
Correct.
Okay. Thank you.
Correct. The third part of our argument is that under the plain language of the negative declaration, the respondents were required to obtain the approval of the Town of Amherst Historic Preservation Commission prior to any demolition, and that just wasn't done. They violated their own negative declaration.
Is that in reference to the garage?
Yes, it is, Judge. I know that, as I said earlier, that
what's the remedy there? What's the remedy there? I got to rebuild the garage, or?
I don't think you can't ring a bell, so I don't think they're going to rebuild the garage. But they should be told that if they're going to take actions, and the planning board is going to come up with this negative declaration, they're expected to follow it. And they're expected to follow the town ordinances they're subject to, and not say, well, you can't enforce that, which is what their argument in their brief states. As far as the mootness doctrine goes, they stated that we didn't apply for a TRO in the appellate division, and that in itself should say that we didn't try to preserve the status quo. We did. We were told by the Fourth Department that we should first try to apply for a TRO with the trial court, which was done and denied. I just want to make that point because I know much was said in the response papers regarding our attempt not to keep the status quo, but we did.
Did you appeal the decision?
We did not. This appeal was at that point, the buildings were immediately taken down. There was no point in trying to appeal it. So we did not, but we did attempt to obtain a TRO prior to those buildings being taken down after the decision was rendered. Just in conclusion, the town failed to take the hard look and provide the reason elaboration under seeker. We believe that it ignored its duty under General Municipal Law 239M to resubmit the plans to the county, and that this decision of the town planning board should be annulled, and the matter should be remanded for full seeker compliance. And if you don't have any questions, I'll rest on my papers.
Well, thank you, counsel. Thank you very much.
Thank you.
Good morning, John Henry Whiteman, Osman and Hannah on behalf of Respondent Benderson Development. I wanted to start with the mootness point because, as your honors pointed out, the buildings have been taken down. So if I could just briefly describe these buildings, these were 1950s to 1960s eras storefronts. They had been vacant for many years.
I believe we've seen some photos of them in the record.
And so
Square building, right? Square building?
Correct, your honor. And
number 10.
Correct. And it had, in fact, been used by the fire department for training. They had punched holes in the wall, in the walls of the building in order to do whatever fire department training. These were not pristine historic buildings. They were rather poor condition. After obtaining the approvals, my clients started commencing demolition and started the asbestos remediation work and asbestos removal work necessary to clean up the buildings before they are taken down. While that work was being undertaken, the proceeding had been commenced, and then injunctive relief was sought. We were stayed for a period of time. When the lower court issued its decision, it lifted that TRO and the buildings were taken down. So in our view, that renders this appeal moot. Certainly any allegation that the historic impacts of the buildings weren't adequately reviewed is moot. These buildings are down, and in fact are asbestos covered. The bricks can't be put back together in any event. And the claims that the petitioners made here were really only that seeker wasn't complied with because there wasn't a hard look taken at the allegedly historic nature of these buildings. Well, that's clearly moot. And then the only other claim that they made under seeker was that the traffic study was deficient because
the traffic study, in their view, only used data that was developed in 2021 during the pandemic.
Didn't they make a claim about the environmental impact study?
Correct. So their claim is that because the planning board didn't take a hard look at those two issues, that the planning board should have required an environmental impact statement. We submit well, first of all, the planning board clearly took a hard look at the allegedly historic nature of these buildings, and given their condition, and had two reports in front of it, which found that there was no historic value to these buildings, particularly given that their condition, the fact that they had been previously disturbed, there were no events of historical significance associated with the building, none of the other applicable criteria that would warrant historic designation applies.
Was this historic argument ever issued at any time when the fire department was punching holes and training it?
Apparently not. Yeah, apparently not.
Right, so that was okay. That didn't disturb.
Perhaps there were some 1970s clothes sold there at some point in time, but that wasn't deemed historically significant.
But at the time you undertook this project, the buildings were compromised.
Correct. That is absolutely correct. And so they were acquired for the purpose of.
And also know the area, and Main Street is a busy commercial, like, so I know that the neighborhoods are lovely that are involved in this, but they're tucked down and around.
Correct. And that ties into two of my points, which is they have now, I'm going to come back to the traffic study if I may, but they now appear to be arguing, well, the planning board didn't take a hard look at community character impacts. This property is specifically designed for this use. So my client did not require a use variance, did not even require an area variance. The town has a specific zoning designation for the purpose of building mixed-use commercial and residential properties on these sort of end caps of the residential areas.
What it was and what it's going to be, right? I mean, the same type of.
Correct. Of the modern version of what it was. It will have a residential component and be more of a mixed use, but the idea being is that you would still have that commercial use on Main Street, and the best indicator under the case law of the community character is what the zoning of the property is. Given that we're specifically zoned for this use and don't require any variances, it's rational for the planning board to find that we fall within the community character. With respect to they did make a claim with respect to the traffic study, and the claim was that the traffic study should have been disregarded because it collected data in 2021 during the pandemic. First of all, that's just conjecture. This was done in July of 2021. Restrictions had been lifted. We were pretty much back to normal at that point, but it also completely ignores the fact that my client went and got a supplement to the traffic study collecting data in December of 2022 to account for any updates.
But that wasn't the updated, they didn't reapply, they didn't give that to the county, the supplemental.
I believe that the supplemental, I'm not sure if the supplemental traffic study was given to the county. I am not sure of that fact, but the claim that the petitioners are making is not that. The claim that they are making is that we changed the project during the course of the project, and those changes, by the way, reduced the scope of the project, that we were required to send those changes to the county. This court has a decision called, I believe it's Cobb Hill, which is cited in our brief, follows the other appellate divisions, and saying that, yes, when you change a project during the course of review, you don't have to send it back to the county unless the project is so substantially different that it is essentially a new project. And the argument in the Cobb Hill case was there were units added into the project, and the argument was, well, that's more likely to create a countywide impact. The county should have a say here. These changes, it's undisputed, removed units from the building and increased the setbacks so the neighbors had a little bit more room and preserved the house. There was a home on the side street that originally was going to be taken down. My client agreed to preserve that. So all of those changes actually lowered the scope of the project, made
Not the garage.
not the garage. The garage, by the way, was found to be of undefined date of construction, and the garage was gone at that point anyway.
How much of the building has been completed since the appeal?
It has not been. It has not been. They're working on the business conditions necessary to construct, and there may be some changes made to the project to accommodate.
I think there's an allegation that the planning board never explained the reasons for the negative deck. There was conclusory remarks only, and it wasn't specific as required.
I don't believe that's true. Your honors can read the negative declaration. They set forth their reasons. The standard of review is so long as there's any reasonable basis in the record to sustain the planning board's determination, it's to be sustained. And again, the only claim in the petition the only claims in the petition as to sufficiency of the negative declaration related to the historic impacts and the traffic study. So, there's not much else, by the way, to do in terms of an environmental review of this project. This is an already disturbed site. There's no wildlife study or analysis or anything like
But then
that.
why wouldn't the long seeker EAF form be submitted to the county? Why wouldn't that?
Well, I know the planning board did do an FEAF, a full environmental assessment form. I don't believe that there's proof in this record that that wasn't submitted to the county. Now,
I think we can be there.
and in any event, ultimately it's for the county to decide what it believes to be the full statement, right? So if the county required further documentation, it can ask that. It had a full record before it from which it could draw the very simple conclusion that this was a matter of local concern only. There's no countywide impacts here.
Okay. Anything else?
If the court has no further questions, I'll rely on my brief for the remainder. Thank you.
Thank you.
May it please the court, Erica Massler on behalf of respondents, the town of Amherst and the town of Amherst Planning Board. We join in and concur with the arguments made by our co-respondent. I just wanted to make one point on this newly raised claim that there's been a violation of the town's historic preservation ordinance. That claim is not properly before this court. It's newly raised on appeal for the first time, and it's also necessarily based on facts that arose after Supreme Court's entry of judgment. So the attempt to introduce that new claim on those facts is improper and violates fundamental principles of appellate review. If the court doesn't have any other questions.
I do have a question. Why didn't the town update the form that they sent to the county? Why didn't they send the updated civil design plans and the engineering report and the additional traffic study?
Unfortunately,
send those to the county.
I don't know the reason that didn't happen. What I will say is that the town acted promptly in referring the matter to the county planning board, and the town conducted a comprehensive review over a number of months. My guess would be that it was just sort of the rolling nature of the way things came in. And it took a while for the county to get back to the town, but unfortunately I don't have a concrete answer as to why. But in any event, as Mr. Henry said, all of the modifications were to reduce the scope of the project. Any other questions? Thank you.
Thank you, counsel. Okay, case number 571, Hunt versus County of Ontario. And counsels, I'll point out that not only are you the last case for today, you're the last case for the term. So
This bodes well for one.
No, it has no effect on the merits of anything, just telling you.
And this is my first time before this court.
Oh, well,
So a lot of
well,
good things going on here.
You stayed all day and you listened to all the arguments.
It was helpful. Hey, please the court, Nathan Thomas for Ontario County. The integrity of CPLR 201 and the statute of limitations is at stake here. This is a technical case. The trial court recognized that and explicitly did not want to apply the technical rules. There's only two exceptions to the statute of limitations, tolling and relation back. The question is whether this court wants to add a third, which would be for the trial court's subjective equitable considerations, which the Court of Appeals and the Ellie Cruikshank case held cannot apply. So in other words, any party who violates the statute of limitations will cite this case to say, even though I moved for specific relief and I was granted that exact relief, and I took all the steps commensurate with implementing that relief and I violated the statute of limitations, what I meant to do was something else that did not violate the statute of limitations. That would entirely subvert the concept of estoppel, since the county, in this case, never had an opportunity to oppose any of the alternative things that the plaintiffs now said that they meant to do. They meant to change the caption. They meant to substitute a party. They meant to correct a misnomer. Never had an opportunity to oppose any of those things. In fact, plaintiffs are stopped from arguing that they did anything other than add a party because they prevailed on their cross motion to add a party. Trial court did not.
Did they add a party or did they substitute an existing party?
Could you repeat that? I apologize.
Did they add a party or did they substitute the name of an existing party?
The plaintiffs chose to add a party. They cross moved to add a party. They were granted that exact relief. And all the actions they took subsequent to that were commensurate with adding a party. Namely, they served a late notice of claim, naming Ontario County for the first time. They served and filed a supplemental summons, which you only use to add a party. They did all of those things correctly. They just did them untimely. They did them late.
But you did a 50H hearing.
Correct. So I represent Ontario County, right? And as I'd mentioned, they had initially named.
So you represented the sheriff's office at that 58 hearing.
50H hearing.
I represent Ontario County, and the sheriff's department is an administrative arm of the county, right? So when
They're not a separate identity, are they? Sheriff's office?
It's an administrative arm of the county. So when somebody improperly names an administrative arm of our county, I'm going to appear and I'm going to move to dismiss it, lest I have to move to reopen a default judgment if I sat back and did nothing.
But do you conduct a 50H hearing before or after you move to dismiss?
We did it before. And in doing so, by no means did we waive our right to only defend actions that are filed timely against us.
Does the sheriff's office have a separate legal identity?
No, not in this context, no.
Right. That's it. That's the Abbott versus County Berry case, right?
So in this case, our trial court did not have the authority to read into the plaintiff's error and figure out what the plaintiffs meant to do and justify or absolve their error for them. Likewise, plaintiff's failure is not for this court to correct, forgive, rationalize, or endorse. Plaintiffs didn't do their due diligence in commencing this lawsuit. They didn't file it at the outset in the correct county. They filed it in Livingston County. Not for nothing, that cost them 4 months of their own statute of limitations. And they wouldn't consent to move it to Ontario County when I asked them, so I had to move to do that. This will cost them 4 months of their own statute of limitations time. They also, as you know, didn't sue the correct entity. They named the Ontario County Sheriff's Department, not Ontario County. I made them aware of this at the earliest possible opportunity when I moved to dismiss. They were aware of that fact early on. They still chose to wait to rectify that error until after the statute of limitations expired. They had 49 days to file their amended complaint that properly named Ontario County for the first time. 49 days, they did not do so, with no explanation in their brief other than, well, what we meant to do was just change the caption. What we meant to do was substitute the party. What we meant to do was correct a misnomer. That is not the relief they moved for. That is not the relief that was granted. And that is not the relief that they took steps to actually implement.
You don't serve a late notice of claim if you're just changing a caption. You don't serve and file a supplemental summons if you're just correcting a misnomer.
How's this not relate back?
So all the jurisprudence on relation back that I've found says that there has to be a valid pre-existing action to relate back to. So as it relates to Ontario County, there is no valid pre-existing defendant to relate back to because the sheriff's department is not only a non-suable entity, but they're now also a non-party. So in all the cases I've found, the threat of jurisdiction relates back to a valid pre-existing defendant. Here, we don't have that. All we have is Ontario County standing alone, having been named after the statute of limitations expired. So our position is the relation back doctrine does not apply in the first.
You don't even get back to united interest, is that what you're saying?
I'm going to talk about that right now. Notwithstanding, so we believe relation back doesn't apply in the first place, but even if it did, united interest can't be satisfied because how can you be how can you be united in interest with a non-suable entity that's no longer a party?
Well, wouldn't the local law create that?
The local law makes the county liable for the acts of its sheriff, but the county can only be liable for the acts of its sheriff if the county's been properly named in a lawsuit within the statute of limitations. So they mentioned in their brief, they meant to change the name. They meant to substitute a party. They meant to do anything other than add a party, which is explicitly what they moved for and what was granted, right? There is no legal support in their brief for that position, by the way. They cite zero precedent, zero statutory authority that says that they can now backpedal and say what we meant to do was a thing that did not run afoul of the statute of limitations. The record is clear about what the plaintiffs meant to do. And they were stopped from arguing anything to the contrary. Plaintiffs moved to add a new party that cannot relate back to any other party in this action. And they had plenty of time, 49 days, to commence this action against the new party, but they waited. And they violated the statute of limitations. And the trial court endorsed that. And the trial court in doing so committed reversible error. And I'm asking this court to reverse that. Unless you have any questions, I will rest on the briefs.
Thank you, counsel.
Thank you.
Good morning, members of the court. It's a pleasure to see you all today. May it please the court, I'm Richard Amico. I represent the plaintiff Elise and Christopher Hunt in their claims against the county. And I believe the court has my argument, but I think that one thing has to be important here is that a notice of claim was made within the proper time. And it was served upon the county attorney's office, and they had accepted the claim, and then they had scheduled and conducted a 50H hearing. All the while during this period of time, while the 50H hearing was being scheduled and conducted, and then afterworks from that, is that there's no mention by the county attorney, by the way, the sheriff's department is an unsuable entity. And then to make a motion to dismiss the complaint, then saying that you've got the wrong party is disingenuous and it is not equitable to then say that you can set up a defense like this and then spring it upon the plaintiff then to dismiss their case. The relation back doctrine requires that there is the same transaction and occurrences from the original pleading to allow the next pleading to relate back to the timely filing of that summons or complaint.
Why don't you tell us what exactly you asked for from the court below?
I'm sorry, Judge?
What exactly did you ask for from the court below?
What we asked for is to add the county, but the court had treated our asking to add the county as a substitution of the county for the improperly named sheriff's department. And if we're going to reduce this down to the finest point and to make my argument the most clearest and concise, the only difference between the pleading that was filed in July of 2022 and the pleading that was filed at a later time are these words. Sheriff's Department, Ontario County Sheriff's Department, and the County of Ontario. So the only difference between those two pleadings are two words, Sheriff's Department. The occurrences are the same. The transactions are the same. So therefore it relates back to the original pleading which was timely filed. And if the court has no further questions, I'll rest on my papers.
Thank you, counsel.
Thank you. It's a pleasure to see everyone again.
Okay.